This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today, we're going to take a little stretch away from direct insurance fraud and deal with a person who must go directly to jail because he fairly entered into a plea agreement that did not guarantee his sentence and then appealed, thinking he shouldn't have gotten such a big sentence. In the United States of America versus Joshua Louis Rupp, a U.S. Court of Appeals for the Sixth Circuit decision dated January 24, 2023, a case involving a fraud that only tangentially dealt with insurance fraud, resulted in 16 years in jail for the fraudster. Pretending to be a licensed security broker, Joshua Rupp defrauded his in-laws and friends of a total of $2.7 million. Among other tricks, Rupp downloaded an app onto his victims' phones so that they could monitor dummy accounts showing excellent, but fictitious, gains. Rupp pleaded guilty to securities fraud. During plea negotiations, the government estimated that his guidelines range would be about 10 to 12 years imprisonment, yet the district court calculated his range to be significantly higher and sentenced him to 16 years. Rupp argued that he entered into an unknowing and involuntary plea because his decision to plead guilty turned on the government's mistaken estimate of his guidelines range. Rupp also argued that the district court should not have increased his guidelines range with an enhancement that covers those who use sophisticated means to commit fraud. He lastly argued that the court imposed a substantially and substantively unreasonable sentence, but his plea agreement and the plea colloquy both showed that Rupp knew that he could not void his plea simply because the district court chose a higher than expected guidelines range. Rupp also used plenty of sophisticated means, including the creation of the dummy accounts, and his plea agreement waived his right to bring a substantive reasonableness challenge to his sentence. In 2015, when Rupp turned to securities fraud, he swindled family and friends alike of millions of dollars over the next 4 years. Rupp targeted his wife's parents as his first victims. His in-laws initially gave him a small sum after he led them to believe that he had connections with a fictitious broker at an established financial services firm. Rupp wasted all of these funds, causing his wife's parents to suffer significant tax consequences in the process. His marriage did not survive his fraud. What a surprise! What woman would allow a husband to destroy her parents just to have a good time? Fraud soon expanded outside his family. Apart from the app that he downloaded onto his victims' phones to monitor the dummy accounts that he had created, Rupp engaged in many other fraudulent acts to persuade them to invest with them. He claimed that the victims could not lose their principal that they entrusted to him because of the nature of his investments. They lost nearly all of it. All told, Rupp took more than $2.7 million from 19 people. He spent at least $500,000 of this money on vacations, groceries, and other personal expenses. He frittered away the rest on bad stock trades. He agreed to waive his right to appeal, except on a few specified grounds, including that his plea was unknowing and involuntary and that the district court had miscalculated his guidelines range. At Rupp's plea hearing, a magistrate judge found that he had entered a knowing and voluntary guilty plea. Before doing so, the judge confirmed that Rupp understood the nature of the charges and the potential punishment. Rupp recognized that only the district court could determine his guidelines range. He also conceded that nobody had promised him what sentence the court would choose, and he agreed that he could not withdraw his plea if it turned out that the court chose a sentence longer than he anticipated. At sentencing, Rupp's counsel argued against the sophisticated means enhancement on the ground that its application, when combined with the other enhancements, would result in improper double counting by punishing him twice for the same conduct. Adopting the pre-sentence report's calculations, the district court concluded that Rupp's guidelines range was 168 to 210 months. When speaking to the court, Rupp suggested that the report's recommended range had caught him off guard because the government in plea negotiations had predicted the range would be 10 to 12 years. The court nevertheless chose a sentence of 192 months imprisonment, and when the court told him he would have the opportunity to appeal, he responded, quote, "Oh, I will," close quote. The Court of Appeal, considering every fact and legal precedent, said Rupp's argument rested on discussions from the parties' plea negotiations that he did not introduce into evidence. Rupp's offense level turned out to be 32, and his criminal history category turned out to be 4. His plea agreement and plea colloquy both show that he knew that any earlier sentencing estimate would not bind the court and that he could not void his plea if the estimate turned out to be wrong. Rupp understood that the district court could impose a sentence of up to 25 years imprisonment for his offense. He acknowledged that only the district court could determine his guidelines range and that the court could vary upward from this range when imposing sentence. Rupp attempted to avoid this unambiguous waiver by alleging that he did not knowingly and voluntarily enter into the plea agreement. The record, however, left no doubt that he knowingly agreed to that specific provision. Rupp instead merely reincorporates the general argument that his entire plea was unknowing and involuntary because of the government's mistaken sentencing estimate. It didn't work, and the district court's order was affirmed, assuring his victims that they could not lose their principal, a lie that only the innocent would believe. Rupp lived the high life on other people's money until it all ran out. His wife left him, and the Department of Justice brought him towards trial. He pleaded guilty, hoping to receive a lesser sentence with knowledge that he could not force the court to agree. He lost. He is in jail for 16 years, and his arguments were dismissed by the Sixth Circuit with alacrity. Insurance fraud perpetrators who commit similar crimes to that which Rupp committed should consider plea agreements and be careful to protect themselves from sentences that they deserve. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog post, and you will receive email notice of every blog posting, usually 5 a week, sometimes 6 or more. And you can also subscribe to the videos on YouTube and on rumble.com, where there are more than 600 videos. They're all free. And if you found this video and these blog postings to be of interest or useful to you, tell your friends and colleagues so that they can also subscribe. And you might also consider subscribing to my Locals channel and my Substack publications, where you can receive for a very small fee more sophisticated, lengthy, or interesting insurance and insurance claims matters. Thank you for your attention.